Good afternoon and welcome to the second of 3 webinars on GDPR brought to you by Marketing Week, where we will look to unpick some of its key challenges in order to help you navigate one of the biggest developments in data-driven marketing since the dawn of the big data age. Today we will delve deep into the challenges around consent, how to communicate with customers to get buy-in, and the best way to tackle legitimate interest requirements. We'll also look at the implications on Programmatic and the relationship with partners in this area. My name is Russell Parsons and I'm the editor of Marketing Week. I am your host today, but you will be pleased to hear I am not tackling this alone. I am joined by Katherine Armitage, Senior Public Affairs Manager for Digital Governance at the World Federation of Advertisers, the global trade organisation for the world's biggest advertisers, and the Managing Director of the DMA Rachel Aldighieri. The DMA, of course, a leading light on GDPR since it was first introduced way back when. We're not slaves to the subjects that I read out earlier. If you want to challenge, contribute, or ask any GDPR-related questions, please feel free to by clicking on the Questions tab at any point throughout today's webinar. Afternoon, both of you.
Afternoon. Hello.
And welcome. Let's start with consent, as I previously advertised. GDPR requires that the consent given for data processing, including for marketing purposes, be freely given, specific, informed, and unambiguous. Now that seems pretty clear, but there are still lots of questions, as was proven in our first webinar that we did. We got lots of questions about it, and no shortage of confusion. We had a question in our first webinar that sort of, for me, sums it all up. What can we do with the data we have now? Should we be starting from scratch? Should we be communicating GDPR and obtaining consent to continue to market to people? Now that seems to me not a planted question, but one that sums up a lot of the still confusion around the issue. Rachel, let me start with you. In what circumstances might you need to gain reconsent?
With GDPR, you don't necessarily have to re-permission all your customers. It really depends on how you collect that data in the first place. So, as you just stated, under GDPR, it's a much higher standard with regards to consent. So it has to be specific, granular. You have to have achieved an opt-in and then properly documented, which is, of course, a theme that runs throughout GDPR. So if your existing data has been collected under those circumstances, you don't need to re-permission. However, if it hasn't, you need to make a decision. You need to make a decision as to how you're going to be communicating with those people. So, for instance, if you are not planning on using channels covered under PECA, such as email, SMS, you are only going to be mailing them or calling them by phone, you could opt for the legitimate interest route. However, if you want to go down the consent route, you need to think carefully, because once you've done that, come May the 28th, if someone hasn't come back to you, you can't contact them again. So it's a really important way of looking at it in terms of the approach. So don't just blast out a one-size-fits-all to request that consent. Test it in batches so you can see what's working for you. Use a multi-channel approach to see how many people do opt-in, test and learn essentially, as opposed to doing it in one-off process.
Thanks, Rachel. Katherine, anything to add in terms of what and in what circumstances people might need to gain reconsent, and perhaps how to go about that through your work at the WFA?
Yeah, I think what's really interesting is that we're already starting to see a little bit companies going into this area. I myself have received a number of emails from different companies recently talking about, what they want to do with my data and would I mind re-opting in. So I think this is only going to increase as we get closer to May, and I think that it's really important that brands think very carefully about this as a potential opportunity to re-engage with their customer base, to build trust, but also bearing in mind the number of different companies that might have my data as a consumer, the number of emails that I might receive between now and the 25th of May, asking me to re-opt in, and what that will mean also further opt-in rates. So as Rachel was saying, you have to bear in mind that not everybody is going to give you their consent again. So then what do you do in that situation? So it's definitely something that needs to be thought through in terms of looking at your customer base and thinking also about what other legal bases are available under GDPR. There are 6. Whether or not consent is the right one before going down that path.
Just sticking, before we go on to other possible, if not consent, then what else questions. Just sticking to what you said there about the question of trust and the issue of communication and how that is a means perhaps to gain that trust. There will be a lot of companies out there who are absolutely scared stiff to go back to people and to say, is it still okay? And perhaps to open that conversation up with them, because that is putting at risk the means to target, the means to send, the means to communicate in the first place. There was some research, which I think you guys have done, Rachel, that 2/3 of consumers said they will be more willing to share data once they have heard about GDPR and what it means for their data. So why? I mean, it's clearly important from that survey result. How can people go about communicating, and is there a best practice that you guys would advocate, and what are the benefits of it?
Yeah, completely. I think GDPR does offer a massive vehicle to drive customer trust. And, those that are scared to get in touch with a customer base are bonkers, because actually, this offers an opportunity to speaking to the customers that you want to speak to. I think gone are the days where our industry is all about volume. It's about quality and that one-to-one relationship of building relationships essentially with your customers. And this enables you to do that. I think one thing that we talk a lot about at the DMA, and interestingly I saw a recent white paper that the agency WPN Chameleon have produced in conjunction with FastMap, and that was really showing, they'd run an experiment in terms of how you can approach this challenge that isn't just led by a compliance and legal department, about bringing the marketing and creative departments into play.
Okay.
And I think we're already seeing, at the DMA Awards last year, the RNLI campaign won many goals, and the success of that campaign is really interesting, where it shows having an agency, having a creative team behind your approach can really add value. So I think seeing the GDPR as a marketing challenge, not just the compliance challenge, is really important.
And for anybody who perhaps isn't au fait with the RNLI campaign, can you describe what it is that they did there and why it was so lauded?
Yeah, so it's an interesting campaign, and perhaps one that could only work fully because they're a charity. So they had a really emotive campaign that used a whole series of media to get people to opt in. They really aligned their cause and the importance of speaking to their supporters to continue what they're doing, and without them there would be no charity. So it was a very emotive campaign, and I think bringing that emotion into the relationship is very important. Obviously that becomes slightly different if you're selling a detergent or something like that, but it's still about brand building within that campaign. It's not just a simple legal communication that's saying we've updated our privacy policy because of GDPR, or having to do this because of GDPR. Sometimes you don't even need to mention GDPR, you just need to mention your approach and explain that fully and be hugely transparent as you can be in terms of your approach to really build that trust and engagement.
Thank you for that. Talking about examples of people that have looked to gain that consent or reconsent, there was quite a famous one that was much discussed on social media that Manchester United recently launched, pitch side I believe it was. You must opt in again to continue receiving emails from Man United. Is that, it's a rather blunt but perhaps effective way of doing things. Would you say that's what people need to do, or is it more of are you missing opportunity perhaps not to involve creative and perhaps have that wider discussion about transparency and trust?
No, I think in terms of the creative approach, I think that it is a good campaign in terms of bringing to the fore what they're all about. Their players, I think, are the kind of voice piece of that campaign, and they're the people that your supporters are going to be relating to. So I think that's really important. How that's then delivered. So this is where the compliance and legal issues come into play is really important. So you've got to get the bits behind the scenes right as well. So make sure you've got the right opt-in boxes and the choices for customers beyond that campaign.
Thanks for that. We're already getting quite a few questions coming in. So to remind everybody that's listening that you do have that option, and we'll get through as many as we possibly can in the hour that we have allotted today. In the meantime, I'm just going to pick up on some of the things that we've already discussed today. Katherine, I think it was you just mentioned legitimate interests, and actually, Rachel, just to come to you just for a moment. Your colleague John Mitchison, who took part in our first DMA, from the DMA, who took part in our first webinar, told us recently that legitimate interest should be your first choice, and only if you decide you can't really use legitimate interest should you move to consent. So maybe actually for this webinar we should have started at legitimate interest. Now, legitimate interest sounds like a very legalese, very compliance-heavy phrase, and one crucially that's perhaps open to lots of different interpretation. Katherine, I'll come to you first. I mean, what is your interpretation in terms of the advice that you offer on legitimate interest? What is it, and how do people sort of judge whether or not it's the right thing to do, would you say?
I think that legitimate interest is a really interesting topic for us to be discussing today. It's definitely one of the good things about GDPR is that we have this kind of quite flexible, risk-based approach built into it, which is kind of what legitimate interest does. But of course, legitimate interest is incredibly subjective depending on exactly what you're doing with the data and what your company is doing, because you need to do this kind of balancing test, which is kind of explained in the regulation, but in short, you need to be balancing the company's legitimate interest, first of all, with the consumer's right to privacy, and be able to show the regulator that you've weighed that up. And then you've also got to think about whether a consumer would reasonably expect their personal data to be processed in this situation based on their relationship with the company, which of course, outside of the legal box, that's incredibly subjective. How do you assess whether or not this meets the reasonable expectations of your consumers? And so this actually comes back to that link between marketing and legal, because in many cases, the people who really understand what a consumer's reasonable expectations are of a company and their relationship with that company is going to be the marketing team. So those kind of insights are going to be really, really important to build into the kind of legal balancing test that needs to be done, obviously, with the legal teams as well.
So if you marketers out there are not already identifying your legal or compliance or data protection officer as your best friend, then perhaps you should make them so as quickly as possible. Just listening to you there, I'm not a legal expert and far from an expert in GDPR, but what you just described there, playing devil's advocate, seems to me to be a nightmare for somebody who just wants to know what the hell I'm supposed to be doing. Principles and risk-based, it's probably the sensible, but there's a lot of potential pitfalls there. What could there be lying in wait for those perhaps who lean too much on legitimate interest? What do they need to get there in order in their head and on paper?
I think it's a really good question. I mean, there's a lot of arguments on both sides. Some people actually say that they think legitimate interest is a more solid legal basis in many cases because of the pitfalls of consent, people clicking things without really reading them and just sort of auto-ticking boxes, whereas legitimate interest actually requires the company to take a step back and really think in a very balanced way about what they're doing with people's data and why. But then on the other side, I have to admit that part of my role at the World Federation of Advertisers is also talking to policymakers in Brussels when new laws and regulations on data are being developed. And at the moment, when we're talking with policymakers in Brussels about a different piece of regulation, the privacy regulation, which I guess we might talk about later.
There's another thing for you all to worry about, by the way.
There is a feeling, I think, amongst some regulators that some companies might be looking at legitimate interest as a kind of excuse not to get consent, which is absolutely not the way that we think that you should be looking at legitimate interest. It really needs to be, you really need to go through this balancing test to prove to a regulator that you're not doing it just because you didn't want to ask for consent, but because this is absolutely the right legal basis to be using for those particular circumstances.
Thank you for that. Just looking at some of the questions that are coming in. Pamela, whose email address looks like she might be in Ireland, either was posing these questions before or we perhaps need to come back to it and underline the answer for her. Her question is, can you confirm A, that reconsent is required, and B, suggestions how to go about seeking reconsent? Two very straightforward questions. I think I mean, I might even be able to answer this one for you, Pamela. Reconsent might be required, or you could use other. In terms of suggestions, I'm hoping anyway that we've answered some of the question, or that particular question in some of what we've already discussed. As I said to you earlier, there are opportunities to ask questions on these issues that we've just discussed, and indeed on others. A lot of people are already asking questions on many, many different things, and we will get to those as quick as we possibly can. Now, I mentioned at the beginning, Katherine, about the implications and impact on what is still relatively new, programmatic. Programmatic obviously has gone from 0 to 100 in a relatively short period of time, and is used extensively by some of the world's biggest advertisers, i.e. your members, both as a means to target more efficiently and arguably more effectively. But I believe that there are lots of questions that you're getting in terms of how GDPR will impact programmatic, and indeed how you should go about perhaps redefining the relationships that you have with those third parties in the marketing ecosystem. Firstly, what kind of problems, actually let's be a little bit more positive, challenges, perhaps even opportunities around programmatic and GDPR are there?
So at WFA, at the World Federation of Advertisers, we recently did a survey with our membership base of sort of about 100 global brand owners to ask about the future of programmatic. So one of the things that came up when we asked what are your priorities for your programmatic approaches for 2018, the top priority was ensuring that our programmatic approaches are fit for purpose post GDPR. So this is something that's very important. Only 10% said this, they'd already done this in 2017. So it's clear that there is still quite a lot of work to do before May to really dig into how GDPR is going to affect programmatic and what brand owners need to do. And I think, it's symptomatic. I think that GDPR is a huge challenge for the entire digital advertising ecosystem. And I think that more than ever before, brand owners are really looking to understand where consumer data is coming from, how it's being used sort of across the data value chain, particularly in things like programmatic. And this is challenging because the current online advertising ecosystem that underpins things like programmatic is incredibly complex and could involve hundreds or maybe even thousands of different intermediaries sort of collecting and touching and gathering and segmenting different forms of consumer data. So we've actually at WFA just published a guide for our members on GDPR and data transparency, working with, how to work with your agencies and third parties on this issue. Because when we've discussed this with our members, what we understood was that there was a need to really help brand owners understand, what questions do you need to ask your agency partners, and then most importantly, how do you validate the answers to those questions? So beyond just saying to your agency, GDPR is coming, are you going to be compliant? And the agency, of course, wants to reassure the client and would say, yes, don't worry, of course, we're doing everything we can to achieve compliance by May. What we're understanding is the clients are demanding now to get a little bit more granularity and a bit more detail on exactly how are the agencies preparing, what are the challenges, where are their gaps, and how can actually the brand owners be involved in that? Because essentially, we're seeing that I think with GDPR, there's going to be a real focus on brand owners sort of taking responsibility and stepping up and being accountable for the entire data value chain that goes way, way beyond sort of the immediate stuff that they're touching within their own first-party data sets. So I think this is a huge piece of work. And it's something which could have a major impact.
I mean, how much of an impact? Because obviously, we're still far from the majority trading programmatically, but we're getting to a point where, certainly with those biggest advertisers, are we talking something that's going to torpedo or slow down or make people take a long, hard look at themselves when it comes to programmatic?
I think it's really funny. It's at the moment legally, I would say there's a bit of a grey area here because of the other piece of legislation I mentioned earlier, the privacy regulation, which is still being discussed actually in Brussels. It's not finalised yet. And the overlap between GDPR and e-privacy means that they're still different. There's a bit of a grey area on, what kind of consent you will need after May for things like cookies. And that impacts the interpretation of how it could affect programmatic. So first of all, there's that grey area, and it means that I over the past few months have been asking lots and lots of different stakeholders across the digital advertising ecosystem. What does GDPR mean for you? And the answers can range from it's going to be fine. It's not going to make much of a difference to
we're all doomed.
Yeah. So I think it really just depends on what approach you take, and I guess we'll see once May comes, and we'll see how the whole ecosystem adapts to it.
Just taking a left turn, and Rachel, I'd be interested in what you've got to say, whether or not you're geared for the next thing after GDPR, but just taking a moment and perhaps having a mini webinar on the e-privacy directive. Katherine, sorry, I will come to you in a moment, Rachel. But you wrote something for us recently, which was like, if you didn't have enough to worry about, here's something else you should worry about, or at least that was my subtext. I mean, just quickly in a few sentences, what is it, and why should people be worried about that? And perhaps is there ways that they can, whilst looking at GDPR, prepare or better prepare for the e-privacy directive?
So we currently have an e-privacy directive in place. It's also called the cookie law.
The cookie law. I remember that.
For most of us, our experience of the cookie law has taken the form of these pop-ups that you'll get when you go onto a website for the first time saying, this website uses cookies. If you continue to use the website, we'll assume that that's fine, and continue to place cookies. So this piece of legislation is now being revised. It's being turned into a regulation. And the revision is twofold. The reasons that the European Commission is doing it is partly because of GDPR. So because the data protection framework underneath it has changed. Obviously, the directive needs to be revised, but also the European Commission has sort of done some research which has indicated that these cookie pop-ups, surprise, surprise, don't actually really work and are not having a great impact on the protection of people's personal data. So it's currently being revised, and what's being suggested is that actually we would move away from pop-ups on individual websites to the consent having to be gathered at sort of software level. So, for example, at browser level. So the first time you install a piece of software like a browser, you'd be asked, are you okay with tracking technology such as cookies being placed on your device? Yes or no? And then once you've made that decision, that would be it. And obviously this could have a major impact on the number of people who accept. It would mean that a GDPR level of consent is required. So the kind of implied consent regime we have now, continue to use the website and we'll assume it's okay, wouldn't really stand up anymore. You'd need to get specific, informed, unambiguous consent, which obviously could have a very, very big impact on the number of people who opt in, and then, feeding on from that, the amount of data that can be used for targeting advertising.
Rachel, anything to add on that? Is that something that you guys are gearing up for as well?
Yeah, definitely. We're busy in Brussels working alongside Katherine's team, to lobby for the best outcome. But I think with GDPR and e-privacy, it's important to take a step back, and the DMA has a code of conduct, which is very much about putting the customer first, around transparency.
It'll never catch on.
And we don't do this just for the fun of it. We do it because it works. It's good for business. So I think there is, you do have to look at the mentality and change it from, what could we do to what should we do. And I think, that is changing. We're definitely seeing that change. But, it's not in the interest of marketing to be annoying customers. You want to be doing the right thing. So while this legislation could be seen as a barrier, it actually should be seen as an opportunity to be doing the right thing by your customers and then hopefully thriving off the back of that.
Yeah, and if I could just add, I think that one of the big pieces of feedback we're trying to give in Brussels at the moment is around just having some clear guidance for companies on how these two pieces of legislation will interact. Because the reason we're doing this webinar today is because many companies are really putting a lot of resources into getting GDPR ready, doing the right thing, embracing this piece of regulation and making sure that data is treated in compliance with it. But on top now there's this kind of unfinalized piece of legislation that might mean that companies have to revisit a lot of this work in a year's time or however long it will take to reach a final text on this. And our message is that what we really need is just some legal certainty on some of these grey areas that this kind of unknown e-privacy revision might bring for companies. So making sure there's some legal certainty and some consistency between GDPR and e-privacy is really important.
Absolutely. And Rosie from Teapot Creative has asked a question very pertinent to this. I'm going to read it out in full. Cookies for a website. Will there need to be a pop-up on the page and the user has to opt in for each cookie? I know the reason why the cookie is running. Is this the death of marketing cookies? You've asked more questions than even I manage in a sense. Right? But any thoughts on any of those, Katherine or Rachel? Is it the death of marketing cookies? And do you need to opt in for each cookie?
Well, it kind of actually comes back to what we were saying earlier about legitimate interest and consent and the different legal bases available. I think at the moment it's almost a question of legal interpretation and risk in terms of whether or not some website owners might decide that they can claim that the cookie is legitimate interest as a legal basis, or others who might say, actually, we think we need consent. And once you need consent under GDPR, it has to fulfill all the different things that we were talking about earlier, so unambiguous, freely given, specific, which is a shift from the kind of implied consent regime today. But it's a question of legal interpretation, really.
It is, and that will just send shudders and shivers down people's spines, I think, interpretation. But, I mean, it seems to me, before we go on to some of the questions that we've been getting in, I just want to try and round it up because, I mean, I've joked along the way about legal interpretation and the fact that people perhaps want binary black and white choices, but here's one for you. You don't have to answer this, but it would be good if you could. I mean, is this an opportunity? Is there a commercial upside to GDPR? Because it seems to me that a lot of people are asking a lot of questions, clearly, on the evidence of what I've seen today, but also not quite understanding it and still feel, no matter how much preparation that they put in, that they're still a million miles. But is there light at the end of the tunnel? Is this an opportunity, a commercial opportunity to embrace? You can say yes or no, or you could explain yourself.
I think completely. It's an opportunity to bring data to the boardroom. You've got to have your data protection officer. They've got to report directly into the board. I think we've been striving for that for years, and all of a sudden it's front and central. And it's a real opportunity to transform the culture within organisations. So again, as I've mentioned, bring it back to being customer centric. And that's super important. So, no, I completely feel it's an opportunity. And yes, it's tricky at the moment, but there's lots of guidance out there now. The DPN document around legitimate interest, which the DMA works on as well, gives you a track through legitimate interest and the legitimate interest assessment, etc. We'll finally be launching our legitimate interest and consent guidance. We've deliberately put that together because they're constantly being pushed against each other this month. So there's lots more stuff coming out. It is late in the day, I appreciate that. But in terms of the way we had to go about getting that guidance, it's taken a bit longer. But there are resources out there, so I would encourage everyone to use those.
Catherine, opportunity?
Yeah, I think GDPR is an opportunity. I think it's we talked about this earlier. It's all about trust and building trust with consumers, which is really at the heart of every marketer's day job, really. I think that what is really interesting about GDPR, we've seen from a global marketer perspective, is that GDPR in a lot of global organizations is being dealt with by a cross-functional team of people working across legal, marketing, IT, digital governance, e-commerce, and because of that, it's really creating a much more holistic approach to data protection, which is really important about, especially thinking not just about compliance from a legal perspective, but how do you, as we said earlier, how do you actually talk about privacy with consumers in a meaningful, engaging way? How do you look at some of the big picture things that GDPR raises, like the impact on the digital advertising ecosystem, and talk about that with your media team as well as your legal team and the marketing team? And this is something that we've been doing at the World Federation of Advertisers for a while, actually. We have a working group called the Digital Governance Exchange, which is exactly that. It's dedicated to bringing together quite a diverse group of functions on a regular basis to discuss some of the challenges which legislation like the GDPR pose to digital governance practices. And it's all about sort of how do brands connect with consumers online in a data-driven, hyper-connected world, and how do we rebuild trust in advertising in a digital world. And so I think that this is probably the opportunity of GDPR, is to really start thinking about how to rebuild trust.
On that very positive halfway point, I'm going to go to the questions that we've been getting in. I'll go again to some of the questions. The questions are many and varied, but there are a lot of things about some of the things that we've touched upon today. A theme that's coming through quite a bit, and I'm going to interpret a couple of the questions that we've got around B2B. Rachel, I know you guys did another webinar.
Yeah.
Other webinars are available, but not right now. Around B2B, I think this week, wasn't it?
Yesterday.
Yeah, I mean, the question's broadly around whether or not there are distinctions and very important distinctions to be made between B2B and B2C. Generally, when it comes to B2B, is there something, or are there things that B2B marketers or legal and compliance people perhaps need to be thinking about that is perhaps more prevalent to them over B2C?
Well, I think what's important to note is the big change in that B2B data is classed as personal information. So you need to be working in the same way, essentially.
Yeah.
However, there are exceptions. So obviously, contacting your existing customer base, you can continue to do that in a transparent way, obviously with all the caveats in terms of enabling them to opt out and that being very clear as to how they do that. But the general principle of GDPR should carry through. B2B shouldn't be seen as a whole separate thing. I think, I feel strongly that often we put B2B in a different compartment, but you're still talking to people and you treat them in the same way. You shouldn't be abusing that. So where there are caveats to B2B, I think that you should hold true to the principle of transparency.
Thank you for that. I won't ask you that question, Katherine, because I know most of your members are very much B2C. So this is a question, well, it's sort of B2B related, and two people have asked it, so I'm going to pass it on. Whether or not it's something that you guys have a thought on, I don't know. But if you receive business cards at events, oh, you're both laughing like this is a thing, okay? Can you process their data? This is a direct question from Yasmin. Can you process their data as legitimate interest? And then there was a similar question. Now, perhaps, genuinely,
this is probably
happens to me a lot.
One of the most frequently asked
questions.
Oh,
okay, all right. I'm late to the party.
And it is interesting actually, because there still is an ongoing debate around it. And I think it's how it's framed essentially at the trade show or wherever you're collecting that card. So if it's very clear what you're collecting it for and that person has bought into that, I think the general idea is that you can do that. But it is up for debate. And we did try to cover that in our guidance in terms of when we put that guidance out for consultation, got differing views. So that's one that we could potentially take to the ICO for a bit more feedback on.
It seems to me that it's a very popular and big question for people. Katherine, anything to add?
Well, yeah, I mean, I think I'd echo what Rachel said. It really depends what you're going to do with that email address, right? Is it if you're just using it to send someone an email saying, it was lovely to meet you, let's meet up for coffee, that's a very different type of data processing than you're going to enter their email address into your CRM and start sending them a weekly marketing newsletter. So it's also a question of really case by case thinking about, all of this stuff. Like we talked about legitimate interest earlier being really kind of quite subjective and depending on the situation. So again, it's just about applying some of those rules on what you're actually going to do with that email address.
Thank you. The next time I take somebody's card at an event, I'm going to have to think very, very carefully about the implications of what I've just done. Anyway, moving on.
Or what you're going to do with it.
Or what I'm going to do on it.
Yeah, exactly. That's the key bit.
Well, in this day and age, I just sort of, bump phones or something, and I'll do it via LinkedIn anyway, but maybe I need to think about that as well. Anyway, moving on. Profiling. That's come up. Wasn't a topic that we were going to discuss today, but it's certainly an issue that seems to be arresting people listening today. Profiling, this is from Patrick, is the question that puzzles me most. If you use external data alongside information you hold to improve targeting, brackets, so excluding ineligible customers, is this good marketing practice as in the customer's interest, or does it require an opt-in from customers? I'm not necessarily asking you to answer Patrick's question, but if we think about profiling, a question for either of you, what is it, what are the requirements of it, and in what circumstances perhaps do people need to consider it?
Yeah, I guess it's how much you're likely to infringe on the individual's rights with profiling. So profiling to enhance the customer experience, whether it's serving up suggested products based on past purchases or profiling that enhances your marketing, I think could certainly be viewed as something you could do using legitimate interest. However, a person can object to profiling for marketing at any time. So I think the main crux of this is that you enable them to do that, that you use profiling in a way that does provide advantage to the customer, again, going back to the customer, and not just for your own purposes.
Thank you for that. Anything to add on profiling, Katherine?
Not really. I think Rachel's covered it. I think the right to object to profiling is an important one, and it's definitely something the marketers should be bearing in mind.
Thank you. Let's just put profiling to one side. I hope that's helped you, Patrick. Now, I'm going to just run through some of these quite quickly and see if we can't get some direct answers. Does GDPR apply to images of individuals or images full stop?
It depends what's on those images. This was raised at a conference recently. If you're taking photos of people at a conference with their name badges on and their job titles, for instance, you need to be very careful because you are displaying personal information. So it really depends on the nature of those images, I would say. Okay.
And there's a question here that's sort of evocative of quite a few. I think I probably know the answer to this, but does verbal consent count? Does a nod, does a wink, does a...
Well, I mean, I think the regulation says you can provide consent orally, but as Rachel mentioned earlier, you need to be able to keep a record of that consent. So I think that's what you have to think about. Like if it's, as you say, Russell, a wink or a nod, how do you record that to be able to show that to a regulator one day?
Yeah, and how would you obtain that? You know, is it in a transparent way? I think that's the key thing with verbal consent. How has that person said yes to you? So yeah, you do need to document how you went about getting that.
Okay. This is perhaps a question for you, Rachel, and broadly, what advice do you have for startups and small businesses that don't have legal departments? Let me reinterpret that question. Clearly, Katherine's and the WFA's concerns are the biggest companies in the world, the biggest advertisers, but I know you guys are a broad church with many and varied size of companies. Is there something in particular that you're telling
small and medium-sized businesses that perhaps don't have the infrastructure, or, I mean, other than get some infrastructure and invest in it?
Yeah, well, I think obviously some companies have limited resource. Now, where the ICO has recently really upped its game in this area, it's issued a helpline for small businesses to be calling them. They've issued new guidance to help small businesses. I think small businesses, just because they're small, shouldn't see themselves as exempt, and I think that's currently a big challenge. I think the Federation of Small Businesses put out some research last week that was showing a very low level of small businesses actually being prepared for GDPR. I think also the way the regulator's going to be approaching this, they act on customer complaints. So I think small businesses, as long as they are following the framework of GDPR and doing what they can and documenting that process and not getting customer complaints, that's the right direction. They shouldn't see it as something that's insurmountable.
Thank you. Lots of questions still to get through, and a little bit of time to do so I'm going to crack straight on. Now, there are lots of questions still around legitimate interests, and we joked a little bit earlier on about it being risk-based or principle-based or open to interpretation. I just wonder if I can't perhaps use Susanna's question as one that evokes the ones that we're still getting, which is whether or not there are examples of cases where it might apply. That's her question directly, but it sort of picks up on quite a few points. Are there instances where it would be the right thing to do, and in what way?
I think, the most obvious way is where you have a relationship with that, so they're a customer, they've bought from you, that's a very clear, legitimate interest. So, there are instances where I think it is crystal clear. But again, it's weighing up that legitimate interest with the rights of the consumer. And I think that the crux of that is, would that customer individual expect to be receiving that communication from you? And if you can't answer yes to that, it's not a legitimate interest.
Okay.
To me, that's the clearest way of defining whether it's the right thing to do.
Okay.
Yeah, it's a really difficult one. It's a question that I think a lot of people have. Like, okay, give me a concrete example. I really want to understand it. And I think actually it's one of those ones that it's really subjective, and I think that it's actually going to take us a bit of time to really get an idea of how that's interpreted also by individual data protection authorities, because that's what it might come down to eventually, is if the legitimate interest as a legal basis is challenged by someone whose data has been used by a company, ultimately it will come down to the way that that's interpreted, if we go that far from a complaint and how that's interpreted. So I think, honestly, on legitimate interest, until we have the first piece of case law that really defines in a bit more specific detail how that's going to be interpreted across Europe in a uniform manner, there's still a big margin of interpretation that's keeping a lot of lawyers, I think, very busy at the moment.
Yeah, well, but I'm not sure that busy doesn't equal lots of cash for them anyway. I mean, I suppose, you've touched upon something that really interests me, because there's this rush to the finish line at the end of May, but at the same time, your eyebrows both raised. I wasn't telling you some new information. It's May. But from what you were saying, you're going to learn as much after May, perhaps. I mean, I know you can't speak on behalf of the ICO or on the EU, but I mean, how much guidance after May is going to be out there? How much can people learn, and what, as I say, there will be this rush to the finish line, but what do they need to think about once it's all in? It's not like, oh, we're all right now, everything's okay. What are the key things that people need to think about once it's up and running? You say the first case studies, the first examples of where people have gone wrong, but
yeah, I think that it's like any piece of legislation. It's the first time that it's going to be challenged in the courts, or in this case, that a complaint will be filed with the Data Protection Authority. and then that goes up to the European Court of Justice. That's probably like the first time that we'll ever get really kind of concrete interpretations that are coming not from just from a data protection authority, but more broadly. The GDPR introduces this new concept of the one-stop shop, in which different data protection authorities will have to have some level of cooperation and uniformity in the way that they interpret the regulation, which is slightly different to where we are today with the current data protection directive, which is obviously much more subject to national interpretation. But at the same time, I think there are still quite a lot of question marks on specific things on GDPR. And I think that nobody's kidding themselves that on the 25th of May, the GDPR work stops. There will be a lot of work tracking exactly how it's being interpreted by regulators, anything that's going to go up through various different courts. And that kind of thing in the European justice system can take actually years. So we still have a journey ahead of us, and I think the advice to companies is just in the meantime to be doing their best and be ready to they're doing everything to get where they need to be and be able to show their homework, right? To be able to show you're working to the regulator to say, look, in good faith, we're trying to get there, but there are places where it wasn't 100% clear, or we weren't entirely sure how to interpret it. That's definitely going to put you in a better place as a company than just sort of going with an interpretation and leaving it at that. I think there needs to be a big degree of flexibility, and as I said, I think really being able to show you're working out is really important.
That's critical. And I think also Elizabeth Denham has said millions of times now that she favours the carrot, not the stick approach. So I think, to Catherine's point, if you are showing that you are trying your best to do the right thing and you've got that documentation, there's definitely going to be a different view on how they treat that case. Okay.
So show your workings out. And show good faith and show that you're looking to do the right thing. All sounds rather utopian and flowery, but it does sound like to me, I mean, if we've ever had an editorial line on GDPR, it would be that if you're doing the right thing, being transparent and looking to gain trust, seems to me to be the right way of going about things. And although perhaps it won't be a legal defence, if it comes to that, it would certainly be a demonstration of good faith and a demonstration that you were trying to do the right thing with your customer interests at heart. But this is not why I'm not a lawyer and why I'm not a compliance expert, because I can be as romantic and utopian as that. Now we've got about 10 minutes left, and we've still got loads of questions to get through. I'm gonna treat this as a sort of quick fire round, shall we?
Oh, God.
There's not, I'm not going to cut you off if you don't answer in 5 seconds. We've still got a lot of questions. I began at the beginning talking about consent and the amount of confusion, despite the fact that consent, as far as I have been reporting on this stuff and reading about this stuff, seems to have dominated the question, but there seems to me to be still a lot of questions. So I'm going to ask them. We keep hearing the phrase double opt-in. Please could you explain exactly what this means? Now, I have to say, Gabby, I've never heard that phrase, but do either of you have perhaps an idea of what that might mean and what the implications for people might be?
I think the double opt-in is when you receive something or you're on the website and you opt into something and then you get an email to confirm that opt-in.
Yeah.
So that double opt-in isn't required as part of GDPR. The requirements have been set out around consent and making that very clear and unambiguous and not bundled up into anything else. So you could go down that route if you so wish to, if you felt that was the best way of doing it. But I think if you're very clear up front, there's no need to do that.
Okay, thank you for that, Rachel. If you don't have consent to send emails, does emailing them to ask for consent break current rules?
Yeah.
Current rules, I think.
Yeah, so Honda and Flybe are cases in point, so the ICO issued fines for them doing just that, actually. So, yeah, don't do that.
Good. That's very clear advice. This is a rather lengthy question, but please bear with me. Hi. We have some 30,000 current clients that we send a monthly e-newsletter to, highlighting potential changes to policies, legislation, advice on policies that they may benefit from. If these current clients, have not explicitly signed up for our e-newsletter, can we cite legitimate interests as a reason to continue to send them after GDPR becomes law? Sorry, it was a question about legitimate interest, not consent. I thought it might be about consent. So basically, so it's a question really of that they haven't explicitly signed up for our e-newsletter, but they're getting it anyway.
It depends who these people are and how they got them on the list in the first place, really. So if they must have got their data from somewhere. So how they got that data, so if they got consent for that data, they need to look back at how they gained that consent. Or if, in terms of that being a service, if it's, say, a membership or their customers, there's scope for legitimate interest there, definitely. But it really has to go back to where that data came from in the first place.
Thank you. When asking for reconsent, do you need to be specific to what they're signing up for, or specific about what they're signing up for?
So under the GDPR, the definition of consent is that it has to be specific and informed. So, I think as general good practice under GDPR, any form of consent needs to include providing enough information for that consent to be specific for a particular purpose.
Thank you very much, Katherine. My screen is just frozen for a moment, so just bear with me while it comes back. A lot of questions still around consent, but you know what? I think we've probably tackled the vast majority of them. There are further resources that you can call on. I'm sure the DMA has a wealth of information.
We certainly do.
On consent, on legitimate interests, on B2B, and I know that you guys at the WFA are doing a lot of work, and people can check out your website for more information on some of the implications affecting your members. You can come to marketingweek.com for lots of discussion around some of the implications and some of the big issues around what's next. And also our sister brand eConsultancy is running skills workshops online, and you can find more details at econsultancy.com if you're interested in online practical learning around GDPR. I'm going to just pause there and thank my two participants in this webinar today. Rachel, thank you very much. And Katherine, that was very illuminating, and I hope everybody listening out there has learned something today. And we didn't get a chance to ask all of the questions, but we did get through quite a lot. And you can listen again, and this webinar will be posted on marketingweek.com, and you can listen to it by the Workcast platform as well. Probably over the next 2 or 3 days that'll be ready. So thank you very much for all of those that took time out of your afternoon and listened today, and good luck with everything. There seems to be a very positive message coming through of opportunity, and as much as there is about the million things you've got to think about in the meantime, it is about doing the right thing. It is an opportunity to redefine your relationship and perhaps look for a greater level of transparency. So think positively, as well as how much you might have to do in the meantime. Thank you very much, and goodbye.